Welcome back to the pause. Now let's settle for the details, because this afternoon we're going to spend a lot of time in court today understanding the legalities and the technical words that were used today, and to try to make sense of what had happened today. Now, efforts to resolve some legal disputes which President Akufo-Addo has cited for his refusal to receive the bill, that's the Anti-LGBTQ Bill, have set a snag. Now, one of the cases filed by Richard Delasky has been adjourned indefinitely to allow the legal practitioner and broadcaster to file a fresh motion to take care of some mistakes in his earlier motion. There were also some intense verbal exchanges between the Chief Justice Courtroom and lawyer for the Speaker of Parliament, Tadio Sorry, member of our Legal Affairs Desk, Asante, such through proceedings. And he joins me here with more shortly. But first, here are excerpts of what transpired in court this morning.
Mary Wendy Yeboah, we have 7 pages. It was that omission.
So you just said Mary Wendy Yeboah filed, please hold on, let me land.
No, I'm not going to say.
Mary Wendy Yeboah filed another affidavit on the 2nd of April?
No.
Is that what you're saying?
No, 15th.
15th of what?
15th of March.
How can you withdraw an affidavit on the 2nd of April and file a second one on the 15th of March?
No, Mary Wendy Yeboah's own was filed on the 15th of March, 2024, at 2:30.
Yes.
Very well. Then Pumaya's was filed subsequently, or it's the other way around. Pumaya's was filed to correct the error on Mary Wendy Yeboah's affidavit. But each of them raised. So my lady will look at Mary Wendy Yeboah's affidavit and realize that from page 5, that's where it ends.
Sorry.
No, my lady, I've got it right.
You can hear me very well.
Yes, my lady.
You appreciate the pickle we are in.
Yes, my lady.
You filed an affidavit on the 15th of, please hold on, don't interrupt me. You filed an affidavit on the 15th of March.
Yes, my lady.
You withdrew it on the 2nd of April.
Yes, my lady.
You filed the second one by Pumaya on the 2nd of April.
Yes, my lady.
So your substantive affidavit before, please.
Oh, yes, my lady.
Always wait for me to land.
Yeah, I'm not going to say it.
Your substantive application affidavit before us is dated the 2nd of April.
Yes,
and is the affidavit of Pumaya.
Yes, my lady. Yes, but
so why are you referring to?
I got mixed up because I have 4 cases this morning, and I just mixed up my paperwork. I've now got it right.
Listen, let me land. If you had just waited to understand my words instead of rushing to justify yourself, you would have admitted that you didn't have a formal notice to object.
Yes, ma'am.
And that your notice to object would be your affidavit. Then you can go on to Pumaya's affidavit. So where in Pumaya's affidavit now do we have your objection?
So my lady will look at paragraphs 7, 8 of the said affidavit. Okay, take it. Paragraph 7 says that the plaintiff applicant's first prayer endorsed on the face of his motion paper is modeled up in the difficult to understand prayer to restrain the Speaker and the Clerk of Parliament.
Sorry, hold on.
Yes, madam.
How is that expressive of a preliminary legal objection to move an application to amend?
My lady, it is
a lawyer,
yes,
like yourself, like you found yourself muddled up this morning.
Oh,
yes, you have. A lawyer files. I can see what his difficulty is. When you read, you can see he left out some words. You chose to denigrate that what happened in his expressions by describing it as muddled and confused. And the man now wants to correct himself by expressing it fully. And you say you have a preliminary legal objection.
Yes, my lady.
Where is the legality?
Because, the legality lies in the fact that the motion paper invokes the jurisdiction of the court. And if there is an irregularity on the face of the motion paper, which I am pointing out as the foundation to which I am not accepting what he has found.
No, hold on.
Yes.
Which motion paper?
His motion for injunction.
The man is not seeking. Hold on.
Yes.
Whenever I start, stop.
Oh.
You are going to interrupt me.
Very well.
Then you wouldn't hear what I have to say.
Very well, my lady.
The man's application is not to amend his motion paper. His application is to amend his reliefs.
Very good. And my lady will realize that I'm saying in paragraph 7 that his first relief is modeled up in a difficult to understand.
Hold on.
Design. And there's a second
Stop,
one.
stop.
Yes.
And this is why I'm telling you that the application before us is to correct that muddled up expression. Do you not see that?
And so I'm saying, so my point is that is my objection to it. But
He should not correct himself.
Oh, yes, because you see,
He should not.
yeah, there's authority on this from this court on that point. That once there's an objection taken to it, you cannot overreach that objection with a proposal to amend.
Hold on.
So that's all I'm drawing the court's attention to.
Stop there, Mr. Stop there.
Yes,
Stop there. We began this morning by my asking, when you spoke about the preliminary objection, I said, did you give a formal notice?
Yes, ma'am.
Hold on. Now, if you had given a formal notice, anyone would have known. But in your affidavit, you only described your opinion.
No, what I found
That's not a preliminary legal objection.
Well, maybe it is not stated that it's stated as an opinion, but what I was stating what I found objectionable about it. And this court has also said that I don't even need that formal notice, that I can get up when he's about to move and take that preliminary objection. Trustees of the Synagogue Children of all nations. And the strain of them from the court that I didn't need.
Mr. Sorry, I'm not impressed by what you are doing.
Very well,
but just finish it.
I'm sorry. So,
finish it.
So I'm saying that
It's not fair to your friend. I don't think so. But you want to do it, do it.
I'm relying on the authorities from this court to take my preliminary objection, that I'm entitled to take it just when he's about to move it.
So just do it.
And my second point is that...
No, what is your first point?
My first point is that...
You have been more muddled up this morning.
Order in court, please. Order.
The plaintiff is not entitled to overreach my objection to the reliefs endorsed on the face of his motion paper on his application for an injunction. Because those reliefs were endorsed on his motion for injunction. And in my affidavit in opposition, I have raised an objection to the manner in which the reliefs are couched.
Hold on.
Yes, my lady. Okay.
The plaintiff is not entitled to overreach. Please, hold on. Let's have some order. The plaintiff is not entitled to overreach my objection to the reliefs on his application for injunction.
Yes, ma'am.
Because
once I have indicated my objection to the reliefs endorsed on the face of his application for injunction, he cannot avoid the consequences of that objection by filing a motion for leave to amend those reliefs and render redundant my objection.
so you want to be able to dance with your objections. That's all.
as every other counsel and party is entitled to. And the case of Ahinakwa II versus Okaija III makes this point that an application for leave should not.
What's your citation?
2011, one Supreme Court of Ghana law report at 205. My lady may want to look at page 216.
And what's at page 2 and 6?
2 and 6. That an application for leave.
Read from page 2 and 6.
Yes, my lady.
Is it read?
It's a bad decision. That an amendment ought not to be allowed for purposes of defeating an objection to a process. And my submission is that the effect of allowing him to amend is that my depositions in my affidavit in opposition, which contests those reliefs in his on the face of his motion paper, would effectively now be defeated. That's the point that I'm making. And my lady, the case of trustees of the Synagogue Church of All Nations, 2010 Supreme Court of Ghana law report, quotes a string of authorities which say that I am entitled to give a notice, formal notice of objection by way of an application, or raise it at a point when he's about to move his motion, since it is a point of law. But Malady, I'll take cue from the point that you've made, that maybe next time I should give him formal notice. But I thought, no, the court says I'm entitled to do the two. But if the court now prefers that we should do one, I'm guided by the court. But I'm guided by the previous decision of the court, which established to my point.
Round up.
Malady, I pray accordingly. It is clear from the two affidavits, even if the court takes the view that one was offensively or purportedly withdrawn, the second one or the first one still contained the same objection. So he should have waited. I think he's overshot the runway. Malady, then the most important thing in the learned Attorney General's submission, and let me corroborate his point that he's my very good friend, is the attempt to even say when the plaintiff has admitted that there is something wrong with his motion paper, he still takes the view that there is nothing wrong with the motion paper. Because by the very motion they have filed to amend, what I'm saying is that the plaintiff himself has seen the problem based on the objection and has filed a motion. Yes, my lady.
Listen. He says there is no material difference between the original relief,
yes, my lady,
and the amendment sought.
Good.
The error only seeks to correct an error in formulation.
And my lady,
that's all he said.
If there is no material difference, there is no point in the application. That's the point. If there's no material difference. Yes, my lord. So
kindly resume your seat. Kindly resume your seat.
Which actually deals a blow to the application.
Kindly resume your seat.
And respectfully, I am supported by Order 20 Rule 8 of CI 47. Indeed, CI 16 has no provisions on affidavits. The only provision on the content of affidavit is as contained in Order 20 Rule 8 of CI 47. And it stipulates that an affidavit shall contain only facts that the deponent can prove. Respectfully, there's no room for matters of law. And I think that, indeed, this affidavit, to the extent that it doesn't bring any new fact, doesn't state any fact at all, ought not to be allowed. Secondly, Rule 9 of Order 20, CI 47, again, says the court may order any matter which is scandalous, offensive, irrelevant, or otherwise oppressive to be struck out of an affidavit. Respectfully, all the matters here are very much scandalous. In terms of the use
You've already said so.
Precisely. And I think that indeed, my left friend has the opportunity of filing an affidavit together with the motion that the court, I'm sure, has already granted leave for him to amend. And he can state it. But of course, he must be cautioned that it cannot be the insertion of any scandalous or argument of law. I pray accordingly.
By court, after listening to all counsel, the court agrees with the suggestion of counsel for first defendant and orders the plaintiff applicant to file a fresh motion paper with supporting affidavit and statement of case. Plaintiff is also given leave to address any matters of fact and issues of law in the new process. Plaintiff applicant is given up to 17th of May. So now you have moved from 9th to 17th of May. Up to 17th of May, 2024, to further new processes. Counsel for defendants are given 7 days after service on them to file any processes that they may wish to. But
I'm proud just to point out that he should address new matters of fact in the affidavit, not issues of law. Especially that would be offensive of the rules. Affidavit contains matters of fact, new matters of fact.
And I said so.
So this is what transpired in court this morning. At the end of this, the decision of the court was that the case has been adjourned indefinitely. The two cases that were before the court this morning. Kwaku Asante was in court today. Kwaku, welcome to the post. Also, let me bring in a private legal practitioner, Mr. Martin Kwebu. Mr. Kwebu, it's always a pleasure to have you here on the post. Good afternoon.
Good afternoon, Mr. Roby.
Yes. So, my apologies for keeping you on the line, but let me quickly allow Kwaku Asante just some few minutes. Kwaku, so break it down to the understanding of a 10-year-old boy. What transpired in court this morning?
Well, this morning in court, the five-member panel presided over by the Chief Justice herself, Justice Gertrude Tokono, Justice Yawa Saridakon, Professor Henrietta Mensa Bonsu, Justice Mariam Owusu, and Les Gaiwu, presided over the two cases that have been filed against the controversial anti-LGBTQ bill. The main order of business for today was to hear the injunction application that those two persons have filed, Richard Alaska, a broadcaster, and Dr. Amanda Ado, a researcher. They are asking the Supreme Court to injunct Parliament from seeking to give the President the anti-LGBTQ bill that the House passed, and seeking to also restrain the President from acting on this. So that was the main order of business for today. But when proceedings started in court, lawyers for Richard Alaska had two applications to make the court. They wanted to seek leave to file supplementary affidavits and application
to amend their
earlier reliefs. Because they had filed a rate that had been endorsed on it, a number of reliefs. That is what they were seeking from the court. And now they were seeking to amend some of them because of the way they had worded it.
Right.
The wording was not so clear, and in fact, that is what Thaddeus Sori described as muddled up. And so they wanted to amend those parts. Like you've seen from the interaction, Thaddeus Sori clearly in opposition to that, but the Attorney General asking the court to grant that application. There was this back and forth for a long time. Ultimately, the court deciding that they will give Richard Alaska and his lawyers the opportunity to file a fresh motion for injunction and file that in court. And then the parties on each side will be allowed the opportunity to review them. Then there was a second case as well.
And they are supposed to respond to the court on the 17th of May.
Exactly. So these parties have to do that. Obviously, the court want to deal with these matters expeditiously, especially now that Parliament will be convening soon. This becomes such a big matter. And so once the application had been granted, that means that the court was not going to be able to go into the substantive motion again, because this is the same motion that the court says they should refile. And so that had been dealt with. They adjourned this case, signed that is indefinitely. Then there was a second case filed by Dr. Amanda Odoi, the same facts,
almost seeking the same reliefs.
Seeking the same reliefs almost, and asking the court to injunct the President from receiving the bill. Again, the lawyers were also not going to argue it because they have taken exception to certain language that they said Thaddeus Sori had used in the affidavit. And normally affidavits are not written by the lawyers, or they are written by the party, and they will normally be, you have been verily advised by counsel and believes him to be true. And they said some of the language that had been used were intemperate and inappropriate. This is a view the Chief Justice and the panel agreed with, that Thaddeus Sori and his clients had used certain language that they felt were too strong. And so they asked him also to withdraw that process that he had filed in court and filed new ones that did not contain those strong words. The bottom line of this is that those two cases today seeking to injunct the president. We're not the substantive case was not heard because of these earlier technicalities. The court has now adjourned both cases indefinitely for these new processes to be filed. Then the court will again reconvene, hear this, and make a ruling.
The Chief Justice explained why he allowed cameras in the courtroom.
Well, the Chief Justice herself has not spoken at all to this. We know that only yesterday, 7th May, the Attorney General Godfrey Debordame wrote to the Chief Justice asking her to allow live proceedings because of the huge public interest in this anti-LGBTQ bill and the cases that have been filed in court. The Chief Justice, as we now know, has approved that request. And in fact, indeed, when we went to court today, we are allowed to go into the courtroom with all our live equipment, our camera. That is something you would normally not be able to do.
Right.
But the Chief Justice having granted that, allowed that. We expect that maybe in the ruling of the court subsequently, when the entire case is dealt with, the court may explain why they did that. But the Chief Justice in the chair today did not speak to that. But after court, the Attorney General says he expects that the Chief Justice and the judiciary will allow the media the free space to be able to broadcast. So this case, up until when the case is resolved, media men are allowed to go in there with their live equipment to beam this live for everybody to see.
And I guess that made your work quite easy today.
Quite easier, because everybody now sees what has happened. You just have to come and give them a brief.
All right. Thank you very much, Kokwa Sante. Is our legal affairs correspondent. He was in court and he brought us those details. Now let me bring in lawyer Martin Kwebu. So, Mr. Kwebu, your initial talks on what happened together, for a lot of Ghanaians, they thought the substantive case was going to be heard. And then we're saddled with technicalities and legal jargons. Eventually, the two cases before the court adjourned indefinitely. It's unclear when the court will fix a date to hear the substantive case. But your initial comments on what transpired in court today, before we now look into the other issues of the live transmission and then the words that the Chief Justice described as, inappropriate and offensive.
Okay, so for me, from a lawyer's perspective, what happened today isn't anything extraordinary. It happens. It's normal. It happens all the time in a lawsuit that you'll find that some phraseology are out of place or did not even feature at all. And so you would want to correct those errors. So it's a normal thing. We are meant to make changes all the time. That's just pretty normal. It's pretty normal.
And then the parties, especially those who are before court, asking the court for certain, rulings on the matter, they've been given up to 17th of May to file fresh motions. So does that mean that until the motion is filed, the court may not be able to fix a date to hear the substantive case?
Absolutely. Absolutely, because remember that the motion, so when we say the motion, that's in other words, the application or the process, the document before the court. The specific one we are talking about is the one for injunction. So the last guy wants an injunction. That's to stop the process of the signing the bill into law to be truncated, right? But here's the case. There are some mistakes in his documentation. So until he corrects all those mistakes, the case cannot go on. But in terms of going on, if you look at the timelines they gave, it is possible that they can return to court earliest end of June. Let me show you why.
Right.
They say the court gave the last guy up to 17th to file. That's about, today is 7th, right?
Today is the 8th of May.
Today is Wednesday, 8th, sorry. So 9 days. And they say when it is served on Attorney General and the others, they should respond within 7 days. So this is what happens. 17th, the last guy files. If he's able to follow up within 4 days, 5 days maximum, 4 days maximum, it should be served on the Attorney General. So 17 plus 4, it can take us to 21st May. That's maximum. But sometimes you can stand there and ensure that it is filed the same day. But if, let's say, you don't have time to follow up, let's give up to 4 days. So let's say maximum 21st. Now, so 21st, Attorney General and the rest have 7 days. So that should take us to 28th of May. So they should file by 28th. Then, once this gets back, so that they also take, when we say file, they also take their documents to the court to present to the court, but not to the judges directly, to the administrators, that's the registrar and his staff, right? So you see, we are 28th of May. Give or take, it takes a few days for these documents to be sent to the judges, because when these are filed, the registrar will have to send various copies to the judges, and then the registrar will confer with its Chief Justice to get a new date. So you see why I said latest end of June. If they are minded to go back, end of June is most likely workable. That's also provided none of the justices traveled. And if the judges traveled on the panel, if the Chief Justice thinks it will delay, because they've not yet heard the case itself, they can replace the judge so that the case can go on. So, if everything works according to plan, it's possible to go back ending of June. But if it doesn't work according to plan, you can go into July.
Yeah, you are a lawyer, and you have appeared before the Supreme Court many times. I mean, the banter on TV, a lot of people, and some of us, saw it for the very first time, the banter that ensued between the Chief Justice and, of course, the lawyer for the Speaker of Parliament, Sorry, words like sit down, keep quiet, don't interrupt me. Are these normal when it comes to proceedings before the Supreme Court?
You see, I'm laughing. When you say normal, that's the, I'm now looking for, trying to process it. So this, what happens, it depends on the individual judge. You see, we have different temperaments. So that's the way to answer it. Some, that's on the side of the judges and then also on the side of the lawyers. So ordinarily, a judge and the etiquette of the rules, the etiquette or the rules say that when the judge is talking, as a lawyer, wait, let her finish. But as to when to see when the judge is done or not done, it's difficult to tell. So that's how come sometimes you see that a lawyer responds, that the judge says, no, I'm not done. So that is where the issue is. Seeing when the judge is done, so that the lawyer can come in, is where the difficulty is. Yes, you get it. So, right. But there's the other side to that culturally. Yeah, there's a bit of our culture also infiltrating in the way we practice. So we're a bit differential to judges, but it's coming down. It's coming down. So gradually it will disappear. Yeah, right. It will disappear. It's natural. It's part of the growth. It's part of the democracy. It's part of development. Decades ago, hey, who born dog? No. It was a lot more controlled by the judges. But democracy is populating. It's getting in there where judges are getting more accommodative. That okay, times have changed, so the banter should be allowed, okay, because it helps to move things faster. So it's just a matter of time. Yeah, when you compare, so you see, when you look at it and then you want to compare to the U.S. Supreme Court or UK and the rest, you see, you would see that definitely we are different. As I said, the cultural setting and everything is different. That one, there's a limit. Let's just allow, we will grow. We will grow gradually. Yeah.
Right. But Mr. Pebu, other issues that came up, the Chief Justice raising issues about some choice of words used by Mr. Tadia in his affidavit. I mean, words like, she cited the use of despicable and desecration in processes filed by a lawyer of the Speaker of Parliament. There was also the use of these people. Justice Tokono cited a description of the private members in one of the plaintiff processes simply as these people. I mean, choice of words, how does it become a matter that a court must look at, pick them one by one, and say that these are inappropriate, and so you should find a way to amend it?
Yes, so so now we are discussing general principles. I'm not in the case, I've not seen the rest of the sentence, so I'm not judging the specific phrases that have been used in terms of the context. I lack context, so I'm discussing the law generally. Yes, generally as a rule, sometimes some sentences and some words can be offensive. So even in our own rules, they provide. So you heard a lawyer referring to Order 20 and then etc. So they'll tell you that when the words are scandalous, when they are vexatious, when they are frivolous, so sometimes the court will ask you to amend when you scandalize somebody. So this one, let's hazard a guess, like despicable. If it is the gay manifestation of gayism,
right?
That I'm not sure, but we're just giving an example because of the context of this. If somebody is gay and you refer to the person being gay as being despicable, certainly that would be offensive. Yes, that would be offensive. Notwithstanding our cultural setting here that generally in Ghana we don't accept gay conduct, we don't want manifestation of gayism. But the reality is that some people are gay. So once they are gay, we ought to be sensitive to them. We can't refer to what they do as being despicable. No. Once they are human beings, we can't. We offend their sensibilities. So depending on the context, some words can be said to be intemperate. Don't forget, look, you see how Ghana we are growing. A few years ago, so about 8 years ago, when John Mahama was president, then Bawumia was vice. When Bawumia started using the word incompetent on Mahama, you see that it was seen as offensive in Ghana. At a point, Mahama couldn't take it. So it's like, how can Bawumia refer to him as incompetent, blah, blah, blah.
Right.
Now, fast forward, today, you see it's a regular word in Ghana.
Yes.
But for us in court, I can tell you that coincidentally, incompetent is a word that we use freely. From law school, you are taught. Because once the staff you put before the court don't meet the standards, generally will say what you brought is incompetent. So for a lawyer, the word incompetent is not an insult. But you look at it, its introduction into our general discourse in 2016, when Bawumia started calling JM incompetent. You see how the reactions were and the rest.
Absolutely.
But now, how many years on? Nobody complains.
Nobody talks about it.
Bawumia himself is receiving the same word incompetent, even with more superlatives. So that's so much for context and development.
Mr. People, before I let you go, two key issues. I mean, there's a huge public interest in this matter before the court because of the implication it will have in our society, what Parliament has done, and the fact that President Akufo-Addo says that we rather wait for the Supreme Court to take a decision on it before he will exercise his constitutional duty as to whether to accept or reject it. Now, the court for this morning decided, upon a request by the Attorney General, to open the door to allow the media to enter with their cameras. And so, the proceedings today was telecast live. First, let's talk about the live telecast of the event and how that helped in terms of the adjudication of the case before the court and in terms of understanding. And then the public interest, for how long is the public going to wait for finality to be brought on this matter? And in terms of general politicking, how that feeds into the general narrative as we head towards the December elections.
Okay, so one, cameras are good. Yeah, when you bring in the media, you are engendering transparency. And justice itself needs a lot of transparency. Yeah, justice needs a lot because we say justice ought not to be done, but
to be seen,
ought to be manifestly seen to be done, right? So we want that even the whole process of it should look very just. So when it is transparent, it helps a lot. So the cameras are going to help. And then in the process, it will even up our game because as we deal with cameras in the court, then we begin to see the deficiency in our rules and the time wasted. You remember how the election petition, because we're transmitting those live, broadcasting that live, we see how in no time it was clear to everybody that we need to change our rules. You can't spend 9 months on an election petition. You remember even in that year, that's the 2012 petition, which was done in 2013. It even had an effect on businesses because at the time, it was said that some businesses were waiting for the result before they would take investment decisions and all that. Fast forward, we came out with new rules that say that now we should finish within, 42 days or so?
Yes.
Yes. I see that we benefited from that. So trust me, this one too, once you bring cameras there and the public follow the proceedings and they comment, you will get feedback that will tell you that some things are not going well, so we should make changes. Because let's not forget, in Article 125, it stated therein that justice emanates from the people. Justice emanates from the people. So when the people feel something is not right, the justice system has to correct it, has to take feedback. So that's good. So the general politics is good. It's good generally. And let the process go on. The last part of your question, or let me say another part of it, is about how much time.
Exactly.
How much time? I don't see generally this case being finished in less than 6 months. Generally, I don't see it coming to an end in less than 6 months because there's a lot to be done. You see, even from the calculations we've done, the next time they'll be coming to court, maybe the earliest will be in about 6 weeks. So, and after that, so when they hear the injunction, there are other processes like directions, further arguments, and then before you talk about adjourning for judgment. Meanwhile, the court is going on vacation on 31st July. So, and returning sometime in October. Returning sometime in October. So, in terms of timeline, generally, it will take a miracle for them to be done in less than 6 months. But if we are using the court's calendar and everything, that will be after 6 months. Yes.
And that means that maybe finality may be brought on this matter after the court return from its vacation. Or there may be a special vehicle that the court may say that because of the urgency of this matter, let's see through and deal with the matter, as expeditiously as possible.
Yeah, it's possible. It's possible, but yes, I mean, why not? Depending on, it's possible, except I'm just looking at it that urgency is so, I'm trying to see the advocacy. Our society is clamoring for the law to be signed by President Kufuor, right? That's what makes it. Okay, I get that side of it. So let's see how it goes.
All right.
Yes, but there are also people's rights at stake.
Absolutely.
I'm also looking at imprisonment and the rest. So they tell you that we should hasten slowly because once there are fundamental human rights to at stake, we should allow all the various shades of opinions and arguments to be expressed so that when the court comes to a decision, it will be one that would be real justice. Let's not stampede the court.
Thank you very much, Mr. Lawyer Martin Pay, who is a private legal practitioner, for sharing your thoughts with us on this matter. This matter is of utmost importance to the people of Ghana. The reason being that, the outcome or whatever the court decision may be will have consequences in terms of the way forward regarding the law that was passed by Parliament. Now, a sponsor of the bill is a member of Parliament for Whole West in the Volta region, Emmanuel Bejura, and he joins me via Zoom to also share his thoughts on what transpired in court today. Honorable Bejura, you're welcome to the pause.
Thank you very much, my good friend. Let me also say good afternoon to my co-panelist, Lawyer Kwebu, and good afternoon to all cherished viewers.
Right, so you followed the proceedings today. At the start of it, many of us thought the court was going to go straight into the substantive matter. Now they had to spend almost 3 hours debating technicalities and eventually came to the conclusion that the plaintiff, in this case Richard Elaskar and Dr. Amanda, should go and amend their earlier motion and then present a new one on the 17th of May. And then I'm sure that beyond that, the court may take a decision. First, your initial reaction to what transpired in court today.
Well, let me first of all thank the Chief Justice for calling this case. As we all thought that he should never call the case, but eventually we've seen today that a case has been called. However, you all know the technicalities that normally happens in court. I'm not a lawyer, but it do happen in Parliament as well, where we are passing laws. Sometimes we use technicalities just to delay the process. The learned lawyer, Martin, has already explained the technicality behind some of this and why sometimes this case is delayed due to the incompetent filing of the case. And so I followed the case today. One of the things that I give out to the Chief Justice is for the fact that since the public issue, public matter, she has decided that it should be opened up. The media was there to cover it. And so I'm happy that we are moving from this closed circuit kind of decision into an open decision where everybody will follow the case. We'll be looking at the body language of the judges as well as both the plaintiff and the defendants, their lawyers, who want to see their body language, whether they are being remotely controlled by somebody or not. Having said that, giving it to the Chief Justice and the justices of the Supreme Court for allowing the camera, I believe it should continue until the case ended.
It's over.
My plea.
Yes, please go on.
My plea though is that this case will be expeditiously handled. I made mention of expeditiously because of the public interest that we all have on this case. We all know why we are here today. In the first place, this shouldn't have been, the case shouldn't have gone to court at all. And the president shouldn't have even mentioned, before even the case got to court, the president shouldn't have mentioned that someone is rushing to the Supreme Court to put an injunction on him for not assenting to the bill. And so for some of us, we have seen that the president has preempted the decision already that the case will go to court. And also, after preempting it, there were a few meetings that some colleagues who sponsored the bill had with the president, and his body language tells us clearly that he's not prepared at all to sign the bill. And so I want to... You
mean you had a meet? Some of your members had a meeting with the president after his announcement that somebody had gone to court and that he will wait for the outcome of the court?
That was just about 2 weeks ago. The Coalition of Proper Human Sexual Rights and Family Value Coalition have been to the presidency, Jubilee House, to meet with the president.
Right.
You can quote me on that. And the indication is that the case is in court. He is waiting for the case to come out of court. So clearly, if he had preempted that the case will be going to court, and he's waiting for the court to give a verdict before he takes decision, it clearly shows that he's not in the mood now. Do you know why? You heard my good friend Martin saying that this case will run into some difficulty. It's not possible that it will be, the judgment will be given immediately. In any case, they'll be going on legal vacation.
Yes, I was coming to that. To what extent are you hopeful? The timeliness of the suspension of this case is very key because of the huge public interest attached to it. And according to Martin Pay's own calculation, the directive given by the court, if they are able to comply with it by the 17th of May, is hoping that somewhere in the middle of June, the court may sit on it, and then it's likely the court will go on legal vacation in July and come back in October. My question was, can the court can a special court sit just to deal with this matter? I don't know what your reaction to this will be.
Well, I would have preferred the second option, that the court will have a special dispensation by sitting on it, knowing very well that there's a huge public interest and international interest, not only internal, but international as well. You know, the international pressure on the president to see whether he's his own man. He believes in what he said. He believes in Ghanaianness, or he believes in being manipulated by the external world, and whatever the external donors or external partners said, that's what he will go by. And so we are waiting for the court to move faster. And so, just as you mentioned, maybe some of us should plead with the court that they should move faster if they can, speed it up, just as we have in Parliament, where sometimes we have certificate of urgency, or where things are taken, within some period, without waiting for the normal process. And if the court can also do the same thing, because they also have their standing orders, they have the rules of court, which I believe that there should be some clauses in that rules of court to say that yes, because this case is of huge public interest, we will work on it and we will expect action on it.
Just two quick questions before I let you go. I mean, the court had issues with some choice of words used by Tadio Sori, who represents the Speaker of Parliament in court today, in his affidavit in opposition to the motion filed by Richard Elaskai. And the court made mention of certain words. For example, Justice Tokoni cited a description of a private members in one of the plaintiff processes simply as these persons. And then she goes on to say that she cited the use of despicable and desecration in processes filed by lawyer Tadio Sori. In his description of the LGBT community, and the court had issues with this. And the court said that you should amend it because this language is absolutely not acceptable. What do you make of this?
Well, in Parliament, we also have unparliamentary words, as you know. There are certain words that you cannot use in Parliament. And so if the court also have issues with language, I believe that it is in the right place that the lawyer for the speaker should amend. And I don't think that is wrong at all. And I believe that the lawyer will do justice, will go by and then amend some of those things, amend some of the words that needs to be amended. And so I don't have a problem with that, because we also do it in Parliament, where sometimes we ask our colleagues to even apologize to if it offends some of members or offends someone else. They are asked to apologize to the member that the issue of offense. And so there's nothing wrong with that. Every institution has its own way of doing things, and I believe the judiciary also have their terms that they use there. Yes, indeed, these are all technicalities. These are not issues that some of us who are not lawyers will understand. Of course. An engineer will not understand some of these legal terms.
All right.
And so I may not understand some of these terms that they use there.
All right. Honorable Judge, finally and briefly for me, I mean, you spent years crafting this bill. I mean, you went through a lot of challenges, finally got it passed in Parliament. Now the Supreme Court has set the ball rolling. Your expectations?
Well, Elton, I just returned. I came back yesterday from Uganda, where we have a interparliamentary conference on family values and sovereignty. And I must say that we applauded the president of Uganda. Even though Uganda, we all know that the whole world, let me say international donors are against Uganda. The African community applauded the president. We even gave him a citation. I mean, parliamentarians across the globe, parliamentarians from Africa applauded President Museveni for standing for the African value, for standing for culture, for standing for things that we know an African, in his tribe. Let me tell you, some of the things that we saw were issues that maybe on another day we'll discuss it. It is an imposition of the words the West on us, which we have to be very careful. And that is why it is, I'm not too happy with the current president, our president, Nadu Dankwa Akufo-Addo, that he cannot stand on his guts to say, no, enough of this nonsense. I want to stand as an African. Look, if your vice president, somebody who you claim to be your driver's mate, can say that as a Muslim, I will not accept this, and you, the president who is a driver, will not listen to your running mate, and you want your driver's mate, somebody who you claim should take over from you, is saying that I will not take it, I will not accept it. And you want to impose that person on us. What are you trying to say? It seems like you yourself, you have a problem. And so, Elvin, this whole anti-LGBT thing, it is not only in Ghana, it is the whole African continent that is against it. And we must stand on our value system. We must stand on our culture. We must believe in what we believe in. Right. We should not allow anybody to impose their value on us. And we should not be afraid at all. I don't know what President Akufo-Addo is afraid of. If Elet was in court and he signed it, I don't see why he cannot sign this. Unless he has something to hide that is not telling Ghanaians.
Right, thank you very much. Emmanuel Bajra is the Member of Parliament for Ho West in the Volta region and also a co-sponsor of the Anti-LGBTQ Bill. That is now a matter before the Supreme Court of Ghana. The court today asked that the plaintiff, or those who are before the court, do certain amendments to their earlier motion by the 17th of May. And then the court will now take a decision when to sit on the matter and deal with the substantive issue. So we're all waiting to hear the outcome of the court and then what President Akufo-Addo will do regarding the bill. Let's see.